Hello, my name is Natalia Porsche, and I am an immigration attorney here in the United States. I have been practicing immigration law for over 10 years, and in this video, I will talk about NTA, Notice to Appear, and what happens if your NTA does not specify date or time, does not specify time or place to appear at your immigration deportation hearing. Okay, so let's look at hypothetical. For example, we have an individual here who was issued NTA. This individual did not appear in court, and therefore he or she had an order of removal in absentia. And absentia removal orders, those are the orders which are issued by immigration judge when the person fails to show up to a deportation hearing. Okay, so now if we look at the NTA, it's a charging document, notice to appear, which DHS, the government, usually files to start the case, right? So this NTA gives permission to an immigration judge to acquire jurisdiction over this specific deportation case. Okay, so this NTA, let's say it has been filed with an immigration judge, and now the government is seeking to remove this individual. Let's say this individual, like I said, did not show up, so we have an order in absentia. And down the road, let's say this individual is arrested and is let's say arrested for a misdemeanor traffic or a violation, or let's say a felony, and now this individual is in deportation again, So, and let's say that DHS is trying to remove her or him, or trying to enforce this prior deportation order, right? So what is the problem here? Well, the problem here is DHS will have a problem of enforcing that, first of all, deportation order, which already exists. Why? Because first of all, it was an absentia, and the most important is that order did not specify time or place where this individual is supposed to appear for his or her hearing, and he or she did not show up. Okay, so this sort of facts will allow you, your attorney, to argue that this prior removal order should not be enforced, and therefore you should be allowed to apply for cancellation of removal. Let's say you have a qualifying relative here in the United States, so that you can apply for cancellation of removal. And as you know, cancellation of removal, in order to qualify for this sort of relief, you have to be here for 10 years and you have to establish a hardship. Now, this 10 years requirement stops when the government files NTA. So this is exactly the case when government files putative NTA. That means this NTA is not actionable. So we have a Supreme Court case, which is Pereira versus Sessions. So this case specifically addressed this case scenario when the individual did not, Mr. Pereira did not show up to his deportation hearing. He had a putative notice to appear, which did not specify time or place to appear, and he had an order in absentia. So down the road, he was arrested, and DHS was looking to get him removed from the United States and enforce prior deportation order. So now he argued that no, this NTA was putative. It did not specify the time and a place, or a place, not and, or a place. This case specifically says time or place. So one or the other. It doesn't have to be both. Okay, so he argued that therefore, first of all, the order was in absentia, and second of all, he qualifies now for cancellation of removal because he establishes that 10 years because he never departed the United States. He has a removal order, but he never departed the United States in the first place. Therefore, this removal order is not actionable because his NTA, notice to appear, is defective under Pereira case. That's what Supreme Court of United States held. So now he is eligible to apply for a cancellation of removal because he can establish that 10 years. Because the notice to appear, a good faith notice to appear, stops the clock. So therefore, you have to establish this 10 years of presence, uninterrupted presence in the United States, before DHS, the government, issues a notice to appear. So when government issues a good notice to appear, this notice to appear stops the clock. So you better have that 10 years. So now, under the facts of this hypothetical, or under the facts of Pereira versus Sessions, Mr. Pereira wins. Why? Because this notice to appear was a defective. It was putative notice to appear, because it did not specify time or place. Therefore, he wins here, and he is eligible to apply for cancellation of removal. So what is the takeaway from this case? The takeaways here is that if you fail to appear in your deportation hearing, and you had order in absentia, you might be able to reopen your case based on your defective NTA, which did not specify time or place. Now, also, this is very important if the government is charging you with federal crime, saying that you re-enter the United States after you was issued an order of deportation, you deported, you re-enter. Here, what your attorney, the criminal-immigration attorney, must do. Your immigration attorney, your criminal defense lawyer, here you need a criminal defense lawyer if federal government charges you officially in federal court with indictment of legal re-entry, right? So now you have to show that it might be relevant that what kind of order you had. Was it an absentia order? And was that order, you did not show up? So it's relevant. The criminal is linked to your order of absentia, right? Or the deportation order. So you have to see whether this order was order in absentia, or whether this order, that NTA, in this case, deportation case, whether it failed to, it was defective NTA under Pereira versus Sessions. So, and therefore, the federal argument is that the federal government cannot charge you with a federal crime, because why? Because that removal order will not stand. Okay, it's defective removal order. And it should be noted that it's not the jurisdictional argument, right? BIA held, and I believe Fifth Circuit later in Cueto Jimenez case held that no, it's not a jurisdictional issue. Immigration judge has a jurisdiction, right? Even if you have a defective NTA to adjudicate that. However, it's not a jurisdictional issue here. It's the issue whether first it was an absentee order, and second of all, you never showed up. Because also what Cueto Jimenez says is, I believe it might be different case, but I believe it is the Fifth Circuit. What also it says that if you if you showed up, even if you have a defective NTA, was issued defective NTA which fails to specify time or place to appear for your immigration hearing, initial immigration hearing, right? And then you subsequently go there with your attorney, or subsequently they issue you the notice to come to court, right? And let's say you're incarcerated and you try to argue that, no, my NTA is defective, therefore, allegedly, you cannot do this, you cannot have jurisdiction over my case because, you know, I wasn't properly served. Speaking normal English, normal legal language, I wasn't properly served. So the government did not serve me properly because the time or a place lacking. But you appear in court, maybe with your attorney, you appeared in court, we came to court, even if you came to court several times, and subsequently you're trying to argue that no, you cannot remove me because of defective NTA. This argument will not work. Why? Because subsequent notices, which was sent to you by immigration court, right? Although they were not NTA, the Fifth Circuit held that they gave you proper notice. Okay, so it only works in the under the circumstances when you have order in absentia. You didn't show up, so now you can, if you qualify for cancellation of removal, you want to reopen your case because now you have a qualified relative. You can argue cancellation of removal and apply for a green card. or even if you have a visa available to you. Let's say you got married and now you have a spouse, U.S. citizen spouse, who file a petition for you. So now you're eligible. So now you can try to reopen your case and establish that your order was an absentia, and plus you was not served a proper NTA under the law. I hope this video was helpful. This is a rather little confusing subject, but you have to try and contact an experienced immigration attorney, so the experienced immigration attorney can request a file from immigration courts and see what kind of order you had. It's very important. I hope you enjoyed this video and this information was helpful. Remember, this was not an attorney's advice or attorney-client communication. If you're interested in setting up a consultation with my office, you can call 228-229-7500. I am located in Biloxi, Mississippi, so we're serving the South. Okay, well, thank you for watching this video. Put thumbs up and subscribe to my channel. Goodbye.